So thank you all for joining us today for our webinar. I'm Dustin Saldarriaga. I'm a senior associate at Scott Legal. And today we're going to be talking about moving from a non-immigrant visa to a green card. This is a very common topic of conversation and a question that we get quite a bit at our firm. We'll be focusing on the employment and business green cards, including the EB-2, national interest waiver, as well as the EB-5, among other options. And we'll also be talking about options for entrepreneurs. Today, we're very fortunate to have our firm's founder, Ian Scott, here to speak with us. Ian has significant experience helping clients navigate from non-immigrant visas to green cards, and he has personally navigated applying for a number of visas. In fact, he's currently on an E2 visa, and he founded our firm on an E2 visa. And his experience navigating the process really does inform the way that we work with our clients. A few things before we get started. Our firm is a full service immigration firm. So though we will be focusing today on business immigration, we also handle family immigration. We handle humanitarian cases, litigation in federal court. We also handle contract disputes if they're based in New York. So please feel free to visit our website and reach out to us if you think we can be of any service at all. This webinar is part of a series. We try to do 2 webinars a month, and we do these on a variety of topics. After this presentation, we'll send out a link where you can sign up for those future webinars, and we do hope to see you on future occasions. After this webinar, in addition to the link where you can sign up for the future webinars, we'll send you the PowerPoint presentation that you see on your screen, as well as a link to our YouTube channel. And on our YouTube channel, we share the recordings of our webinars, the full-length recordings, as well as shorter videos on the full variety of immigration topics. So do check that out. I think at this point, we probably have almost 500 videos on our YouTube channel, and we take a lot of pride in putting out high-quality information for free. If you have a question, I will be monitoring both the Q&A function on Zoom as well as the chat box. So please feel free to send in your questions through either the Q&A box on Zoom or the chat box. I will be monitoring those, and I'll either share those with Ian at the moment they're asked if they're relevant to where he is in the presentation, or I'll save them for the end. But either way, we do plan to get to all of the questions by the end of the presentation. And as I mentioned before, this presentation will be recorded, so please do be aware of that, and we'll send you a link to the recording after the presentation. Without further delay, I will go ahead and pass it off to you, Ian.
Perfect. Thank you very much, Dustin, and it's great to be here. And yeah, as Dustin said, we're going to talk about moving from a visa. So, some of these categories, as Dustin mentioned, I have been on myself. So I was on a TN visa for a period of time for actually, well, almost 10 years. I was on an F1 visa. I'm currently on an E2 visa. I've been in the US on B1, B2 status. So really what we're looking at today is moving from any of these visa categories to a green card. And before we talk about that, though, just want to generally talk about how the green card system works in the US, because it is very different from how it works in a number of different countries. So in a lot of countries, you see a system where the system is a points-based system where you get points for a number of different things. You get points for your age. If the younger you are, the more points you would get. You get just points for education levels. You get points for fluency in the official language of the country. So a number of different things that you can get points for. And then when you get a certain number of points, then you're eligible for permanent residency. Another thing that often you get points for is the amount of time that you're in the country. So if you're in the country for many, many years on different visas, that might be something you get points for as well. So that's how it works in a lot of countries. But in the United States, it doesn't work that way, unfortunately, because it is, the United States doesn't really give any consideration to, for example, how long someone has been in the United States. You could be in the United States. I've been in the United States over 20 years on different visas, and that doesn't impact my ability to get a green card within the United States. But instead, what the United States does is they have a list of green card categories, and if you're eligible for a particular category, you can apply. So and these categories are broken out into, there are more, but just the kind of two large areas are family-based green cards and employment-based green cards. And when you look at the employment-based green cards, you're going to be looking at categories, further subdividing the categories into EB1 through EB5. And all of these, except for EB4, which is the religious-based green card. All of those we're going to be talking about in more detail today. And then on the family side, we are going to touch on a little bit on the family-based green cards as well. But that really is, there's very specific relatives that can sponsor you for a green card, and those are further subdivided into immediate relatives and then preference categories. And then immediate relatives are not what you would think of our immediate relatives. For example, I would think of a brother or sister as an immediate relative, but immediate relative is just a defined immigration term. So it's going to relate to a spouse or a child that is 21 years of age or older, US citizen that is sponsoring a parent. So, and then the preference categories, they are further subdivided. I'm not going to go through all of them, but they're further subdivided into 5 different categories. And then each of those categories are given the ability to sponsor someone for a green card, but almost all of those categories have very, very long waits. And that's something that we're going to talk about a little bit. We're going to talk generally about those waits, not related to family-based, but in relation to all green cards a little bit later in the presentation. Okay, so and I talked about this a little bit already, that the immediate relative versus the preference-based category. But I wanted to talk more about the backlogs and the process, because the backlogs and the process are the same for all green card petitions. So first, let's talk about backlogs. So with the way that the green card system works in the US is that for all of these family-based and employment-based categories, the government, all of them except for immediate relatives, the government has a certain number of green cards that they're permitted to issue every year. And that number of green cards is further broken down by country. So let's say, for example, that someone is looking at sponsoring a sibling. So a US citizen is looking at sponsoring a sibling. So that falls under a particular preference-based category. And each year, the government is allowed to issue a certain number of those green cards. And once once they hit that number, the category becomes delayed or retrogressed. So once it becomes delayed, that means that the green card is not current, so the individual would have to wait to get the green card. So just to give you an idea, under the sibling category, US citizen sponsoring a brother or sister, that is delayed for about 14 years right now. So, so all of these categories, whether they're employment-based or family-based, they're all kind of broken down in terms of a number of green cards that can be issued every year, and then further broken down by country. So what you'll sometimes see, so for example, in the EB2 and EB3 category that we're going to talk about, you'll see that countries like China and India, they are backlogged much more than other countries, right? So there's something called the visa bulletin, where you can look at the visa bulletin and see exactly who is backlogged and when the visas are which countries and categories are current. But that's something that you always have to keep in mind, because you can only get the green card issued if the category is actually current. So then we look at the whether you get a green card through consular processing or adjustment of status. Now, and again, this is going to be the same for each category. So we'll talk about it here, but it relates to all categories. So, always think of the green card process as a 2-step process. So the first process is going to be filing a petition which relates to the objective criteria associated with the petition. So if you're marrying a US citizen, it's going to be the fact that you have a marriage certificate. If you're doing an employment-based green card, or a company sponsoring you for a green card, it's that you've met all of the qualifications related to that. So in the family-based context, this petition is called an I-130. In the employment-based context, it's going to be an I-140, and in the investment-based context, it's going to be an I-526. So there's always this kind of first petition. Now, the second part of the petition is just the actually obtaining the green card. And this is going to always be either consular processing or what's called adjustment of status, which is filing an I-485 petition. So and now the I-485 petition can be filed if the individual is in the United States. And the benefit of filing an I-485 petition is that the individual can stay in the States while that's pending, and they can actually file for work and travel authorization. So if they don't have underlying work authorization, they can utilize the I-485 to do that. And if they're outside of the United States or they're inside of the United States, then what they can do is they can do what's called consular processing. So they're basically getting the green card at the consulate. So those are kind of the two ways of doing it. And as I said, that discussion relates to all of the categories that we're talking about. So now, then the thing to keep in mind again, this relates to the backlogs, because you can only file the I-485 or submit something for consular processing if the actual green card category is current. So that's something to always keep in mind. So now jumping into the the actual green card categories and some options for people. So again, someone might be on a TN visa, someone might be on an O1 visa, and in this case, I say O1 because it more it relates to this particular category. Because what you often find is with these categories, not with all of them, but with some of them, that there is a non-immigrant visa type that is similar to the green card type. So in this case, we have a a non-immigrant visa type that's O1 that basically looks at a lot of the same criteria that you see on the screen related to assessing whether or not the person has extraordinary ability. And in just as with the O1, the individual has to meet at least 3 of these criteria in order to qualify. Now, even though the criteria for O1 are very similar to the criteria for EB1A, the analysis and the assessment for EB1A, because it's a green card, is going to be much more rigorous than O1. So if someone gets a O1 petition approved, they're likely going to have more to get the same petition approved if they took those documents and applied for EB1A, even though the requirements look very similar on paper. Now, the thing that I would also take a look at here is the ability to, with an EB1A, there is an ability for you to self-petition. So that's something that is very, could be very useful, because you don't need an employer. Now, with this, you actually could, let's say, for example, you had, let's say you were doing an O1 and you were working for an employer, or you had a particular agent, and then you decided that you wanted to, perform a similar activity, maybe providing consulting services or something like that, and you are actually able to self-petition, so you don't need an employer to actually petition under EB1A. You can have an employer, but you just don't need one. So that's something that in particular can be very useful for entrepreneurs, like people who want to start their own business. And then again, as I said here, it's a 2-step process here, right? So here, this is an employment-based petition. Remember at the beginning, we said these run from EB1A through EB5. So in this employment-based, family-based, we said I-130. Employment-based, we said I-140. So you're going to file the I-140 petition. Right now, I believe, I haven't looked at the visa bulletin, I'd have to go look it up, but right now I believe all of the EB1A categories are current. But every time you file a petition, you have to look to see if it's current, and then if it is current, then if you're in the United States, you can file an I-485 petition. If it's not current, then you would do consular processing. It's sometimes, sorry, if you're in the United States, you can file an I-485 petition. If you're in the United States, you could also do consular processing. And if you're outside of the United States, you're always going to have to do consular processing. But both of those applications are just going to depend on whether or not the category actually is current. And the final thing I'll say about this is that the idea here is that you meet at least 3 of the criteria that are listed here. However, unfortunately, the analysis does not end there. There's a case, it's called Kassarian, and what happens after if the examiners feel that you've met 3 of the requirements, then what's going to happen is that you would they do a second analysis, which they, and this is a much more subjective analysis, which looks at generally whether they feel that the petition has risen to the level of extraordinary ability. So that's, so it's definitely a standard that's a bit higher. That standard also exists in O1 petitions, but I think it's a lot less likely that it's going to manifest itself in the same way that it could in an EB1A context. So the next one we're going to talk about is national interest waiver. So this falls under the EB2 category. So now let's just speak generally about EB2 for a second before we get into the national interest waiver. So EB2 is broken down into two areas. So one area is national interest waiver, and the other area is company sponsoring you for a green card. So we're going to talk about the other area as well. But before you even kind of move into EB2, so whether it's national interest waiver or the other area of the company sponsoring you for a green card, there are threshold considerations that you have to meet. So you do have to have either an advanced degree, so that's going to be a master's degree or higher, or equivalent, and the equivalent is going to be a bachelor's degree plus 5 years of progressive work experience, or you have exceptional ability. And it's not extraordinary ability, which is what we talked about before. Exceptional ability are a different set of criteria that you have to meet 3 of. So someone, for example, that had a high school degree, they would only be able to qualify under EB2 if they met the exceptional ability criteria. So then if we're moving to national interest waiver, and just one thing to keep in mind is for all of these slides that we're going through, because we're going through a number of different areas and we go through them very high level in this presentation. However, for all of the slides that we're going through, all of the areas that we're going through, we do separate presentations and webinars. So there's an entire webinar on national interest waiver. So, where we speak about national interest waiver for an hour. Because there is a lot of material in national interest waiver. So we encourage you to sign up for those on our events page. They're happening all the time, or you can go to our YouTube channel and pick one of the webinars that are posted there. So now we go to national interest waiver, and we have this is based on a case, an appeals case. So an individual who initially filed a petition and was denied, and then appealed and was successful, and then the appeals body wrote an opinion and said this is the standard. And the standard looks at 3 different criteria, and the first one is that the proposed endeavor, what the person is coming to the United States to do, is of national importance and has substantial merit. So that could be that the person's creating jobs and economic impact, but in a lot of cases it is based on what it is planning to do, and then find evidence, either expert opinion letters or other things that the government has published to show that the government feels that this is something of national importance. The second is that the individual is well, and using entrepreneur in this particular example, but the individual is well positioned to advance the endeavor, and this is something that we'd look at their educational background. We'd look at how far along they are to doing this. We'd look at track record. The USCIS really likes seeing a track record to show that the person has done what they say they will do in the past already. If it's a company or entrepreneur, they're going to look to see that the company is well capitalized, has a strong business plan, et cetera. So if the company's already started, let's say the person's in the US on an E2 or something like that, and the company already exists, then we're going to look at contracts and look at anything that shows that the company is and will continue to be viable. Then third is that the government should waive the labor certification, because the government has already said that it's in the national interest to protect US jobs. So what we're doing here is we're providing evidence to show that the government has a compelling interest to protect U.S. jobs, but also this person, they should waive the labor certification because, for example, maybe some of the things we talked about in the first 2 requirements, or we sometimes will look at the extraordinary ability criteria and point to some of those things and say that, well, this person's so fantastic that it's another reason that you should waive the labor certification. So now we're in EB2 and EB3. So these, talk about them at the same time, but keep in mind that if you're qualifying under EB2, so this is the situation where a company is sponsoring you for a green card, right? So you're working for a company, often on an H-1B. You don't have to be working for the company. There's no requirement to be working for a company when they sponsor you for a green card, because the sponsorship is based on future employment. And but if you are, EB2 is more professionals, EB3 can be unskilled workers and other, if you are doing under EB2 and a company sponsoring your green card, you still have to look back at those threshold considerations: advanced degree, bachelor +5, or exceptional ability. And if not, then the sponsorship would have to occur under EB3. So what happens here is a three-step process. The first step is called the PERM. And that is a Department of Labor process. And what happens here is the employer files something with the Department of Labor. Job description is ask the Department of Labor, well, what should this person be paid? And so the Department of Labor comes back and says that here's the prevailing wage for this person. This is what they should be paid. The job description is key, and the job description isn't kind of a regular job description. It's one that relates to PERM and minimum job requirements. So you can't include anything extra, and you can't include things like soft skills and things like that. It's going to be often, just a function of degree and years of experience, and then maybe any particular specialization that's required for the role. But it has to be minimum requirements. And then the company has to go through a recruitment process where they have to post, ads, and, people will apply for the job. And if during the application process, if the company gets someone who's interested in the job that is qualified, then the PERM process would have to stop. And you could try again later. But it's difficult because these are expensive processes. If you're in New York, you might have to pay $3,000 or so to place ads for this, because you have to place them in reputable sources like New York Times and things like that, and they're quite expensive. So, often with the job requirements, said they're minimum, you can include, like, let's say the job requires a foreign language, but those are all going to be audit triggers, because if you add in a foreign language requirement, you have excluded a large percentage of the US population. So, it becomes an audit trigger, and it would have to be absolutely essential for the person to conduct themselves in the foreign language for that to go through. And again, this is a Department of Labor filing. So once that's approved, then you move to the filing of the immigration petitions, which is, again, this is a employment-based petition, so it's going to be the I-140. And then we talked already about I-485, or consular processing. And then, of course, you're going to look at whether or not it's current. And unfortunately, the EB2 category and EB3 category, I don't believe it's current under any for any country right now. So it's something to keep in mind. It's not significantly delayed for most countries. For India and China, there's significant delays, but something to keep in mind in terms of your timing. And then, of course, with green cards, family members can always join in the process. So they can join either as like spouse can always join, and then dependents, children children under 21 can also join. So then the next one we're going to talk about is EB5. And so this one is, because we went EB1, EB2, EB3, and we said we're not going to talk about EB4. It's a religious-based green card. Our firm doesn't do them at all, or we have not ever done one. But EB5, we do a lot of EB5s, and EB5s are, really people who have significant resources where they can invest $800,000 or $1,050,000 in a new commercial enterprise. And that doesn't have to be new. It can be anything that's created after 1990. There's an exact date. I don't remember the date. I think it's November 1990. And what's going to determine whether or not you invest 800,000 or 1,050,000 is going to be the where the business is located. So if the business is located in what's called a targeted employment area, where the unemployment rate is 1.5 times the national average, then you can invest 800,000. If not, 1,050,000. Or the other reason you can, or the other time you can invest 800,000 is if the business is located in what's called a rural area. You do have to be quite cognizant of which and types of investments or which investment amounts can be included, because you can include, for example, legal fees and administrative fees. The investment can be made over time. So if someone's on a visa, like say E2 visa, and they're investing chunks of money over a period of time, that's no problem. It's just if you are using the 800,000, then you want to make sure that you're in a area that is a TA or rural area each time the investment amount was made. If not, you have to jump up to the higher investment amount. The investment has to come from your personal funds. It can't come from like retained earnings. Like again, if you have like an E2 company that, because the reason I use E2 as a reference is a lot of the times when people are moving to EB5, they are on E2s. And so E2s are, kind of like similar O1 to EB1A. This is E2 to EB5 is a common way to move. E2 and EB5 have quite a few differences. I was on a call this morning where I was trying to explain, not having that much luck, but I was trying to explain to someone that you can't purchase you can't purchase a business and then have that business. You can't purchase a business and have the investment amount included in the investment amount for EB5. It's just unfortunately not permitted. For E2, that's no problem at all. If you're buying, for example, a restaurant, you can purchase a restaurant and, let's say purchase a restaurant for $800,000, and that's going to be, and let's say it was in a targeted employment area, that would be completely fine for E2. But when you come to EB5, unfortunately, it wouldn't, the $800,000 that you invested, if you gave that money, even if you used it to purchase the assets of the business, if it was the same business, same type of business you were creating, even if you used it even if you used, spent the 800,000, gave the money to the seller, and you were purchasing the assets of the business rather than the shares of the business, the 800,000 wouldn't qualify. You'd have to then start the business and then invest another, invest another 800,000 into the business before you would be able to apply for the EB5. And this is crystal clear. Dustin is on the line, did a lot of research in this area, and there has to be, and the reason is because there has to be a link between job creation and the money invested. And the government has taken the position that if you're buying a business or buying the assets of a business, the shares of business or assets of a business, that the money doesn't relate, it doesn't have anything to do with job creation, right? Because the money is going to the seller. The seller's taking the money and they're going to Disneyland or buying a condo or something like that. So definitely, it's an area, unfortunately, that when you do have an E2 visa, you don't necessarily, if you obtained your E2 visa through if you obtain the E2 visa through purchasing a business, then you do have to kind of sit back and say, okay, well, I might be in a position where I have to actually invest another, $800,000, even though you may have already had an investment that was considered substantial. The other big part of EB5 is source of funds. So E2 has a source of funds requirement, but EB5, you multiply that times 100 in terms of the requirement. In terms of job creation, the EB5 requires that you create 10 full-time jobs. They have to be full-time jobs, not part-time jobs. They have to be jobs for U.S. citizens or green card holders. So that's that's definitely something that is very very different from very different from E2. So. And we talked a little bit about the linkage to job creation. So
Great. And Ian, we did get a question that I think is this is a good point to address, which is how long is it taking to receive the employment authorization document and the green card after filing the I-485? They've asked under the EB3 category. I just took a quick look at the USCIS processing times.
Yeah.
For the EAD, you're typically looking anywhere between 9 months and a year and a half for the EAD, for the employment authorization document. And again, that's USCIS's projections. So that's an estimate, could be different, but 9 months to a year and a half is a good expectation. Ian, do you have thoughts on the amount of time for the I-485? I'm
Yeah, I would say
also, yeah.
about a year, but the only thing is that the ability to file the I-485 is new. So the problem, like, because it just started in March of 2022 to be able to file the I-485 concurrently with the I-526. So we don't have a lot of data yet, because before that you had to file the you could only file the I-485 after the I-526 had been approved. So I'd say that, but I'd say that, if we look at other examples of how long I-485s are taking, I would say a year to a year to 18 months. Yeah.
Yeah, and I think they were asking specific to the EB3, but I think that estimate you provided would also apply.
It would also apply, exactly. That's exactly right. Yeah, and that is about what we're seeing, about 18 months, 1 year to 18 months, depending on the because the hurdle, the much harder part of any of these petitions is the well, the harder part of the EB2, EB3 perm is the labor certification. That's because other than that, like, you're basically just saying that, sponsoring someone under EB3 because they have a bachelor's degree in accounting and they're going to do an accounting job, right? So once you've gotten through the labor certification, the rest of the petition is fairly objective. Like, if they have the correct degree, the job relates to that particular degree, and you've already tested the labor market and can't find US workers, right? So it makes it a lot easier. But the really subjective petitions are more like EB1 and national interest waiver. Those ones are a lot more subjective. Even EB5 is not that subjective. Like, the rules are quite clear, right? Like, it's clear that you have to invest 800,000, clear that you have to create 10 full-time jobs, quite clear rules. So
Perfect. Thank you.
no problem. So then we have some other green card options. We're not going to spend a lot of time on these, but just so you're aware of them, diversity lottery. We have clients. We had a client just this year that won the diversity lottery. She's an E2 client. She won the diversity lottery, and we have done many of our E2 clients in particular seem to have good luck with the diversity lottery. And then there are humanitarian based green cards, like, it's helping police with a crime, and then other, like, domestic violence green card petitions. And then we, of course, always have hope that one day that they will maybe reform the immigration system and make it like the way I described the way some other countries have a points-based system, because those proposals have come out in prior in prior legislation, bills that didn't ever go anywhere, but in terms of that thought process, that the thought process of creating a system that is more of a points-based system, because that taking into account all of those factors. I mean, you may have to decide on the factors, because some of the factors will be maybe controversial, but it seems to work in a lot of other countries in terms of and then also, if you can't get points on one factor, then you may be able to get points on other factors. So that's something to keep in mind. So then the other thing to kind of keep in mind is timing considerations. Some of these petitions take a long time to be approved, like EB5 can take over 4 years to be approved. We've had a lot of success after petitions have been pending for a period of time to file mandamus actions, asking a court to kind of step in and assess whether or not the timing associated with the petition is reasonable. And often in those cases, the government will adjudicate the petitions. Usually you can't kind of just file and then 6 months later file an EB-5 and 6 months later file a mandamus. Usually it's going to be over a couple of years before you would want to do that. But it is an option, especially since the times have really ballooned out for EB-5 petitions. And then because you always, like, when you file something, you always have to, especially if you're in the United States, you have to make sure that you are maintaining your status, right? And we do have some instances where people are filing multiple green card petitions. So we had someone who was approved under the direct investment EB-5 program, and but she was probably still eligible for national interest waiver. And so we're working on that for her as well, because the national interest waiver is going to be faster. It's going to be because the other thing with EB-5, which I probably didn't mention, was that you initially get the green card for 2 years, conditional green card for 2 years. And then after that, you have to file another petition, which is called an I-829 petition, to remove those conditions. So it's going to be with the EB-5 process, it's going to be probably a 10-year process before you actually get an unconditional green card. So we just recently filed another mandamus related to an I-829 petition, which the person had been waiting for over 3 years for that approval. So they'd been in the system probably for they were a bit earlier, so their I-526 approval was a lot quicker than the ones we're seeing today, but they were in the system for definitely over 5 years. So planning is really the key for all of this. So.
Perfect. So, Ian, thank you very much. We do have a couple questions that have come in during the presentation, and if anyone else has questions, now is the time to go ahead and send those in. The first is I guess an applied question, and since we do deal with E2 visa applications quite frequently, for an E2 visa holder who is in the US as an essential employee, do you have thoughts on which green card category might be ideal for them, if any?
So if you're on an E2, it's an essential employee. One that you might want to look at is if you worked for the company before you got your E2, if you worked for the company abroad, then you could look at EB1C. It's not one that we talked about today, but under the EB1 category, there's A, B, and C. So we only talked about EB1A, which is extraordinary ability, but there's also a category which is EB1C, which the criteria, it's similar to the L criteria, where the individuals worked for the company for 1 year at least abroad in the last 3 years, and there's a qualifying relationship, so it's a subsidiary, and then the person has an executive or managerial role. So that's one way that you could look at it. And then other than that, it might just be the other things that we talked about. But that was the only one that I didn't go over, but that one could relate a little bit more, depending on whether you work for the company before.
Perfect. And then a question came in about the general flow of green cards, and specifically, basically the way that the law works is there are a certain number of green cards that the government can issue, and a certain number of those are allocated to family-based categories versus employment-based, and there is some spillover. So the question is, let's see. First of all, in the past, USCIS moved green cards from the family into the employment category, again, spillover. Are these and Ian, I'm not sure. This one, I'm not sure if we're aware. Are these reassignments related to the USCIS's inability to process family-based category green cards? Can lost family-based green cards be recaptured? Do you have thoughts on that?
I don't. I think the answer is very complicated. So no. Because I do believe that there is a mechanism that USCIS uses to to like it's all associated with the visa bulletin and how it is that they're calculating the numbers, right? Like how why is something retrogressed, and is there ability to if let's say that the let's say that the green cards in the EB3 category weren't used, can they be moved to the EB2 category? And I think that there's all law behind all of that, but I think it's just very, very complicated. So I don't know the actual answer. Yeah. Because there's
Absolutely.
a guy, he used to work at the visa doing the visa bulletin. I think his name's Charlie Oppheimer, and I sat in on some of those sessions, and definitely get the sense that it is a very complicated area with respect to how it is that they're, because I think what happens is sometimes some get used, and then sometimes it actually just gets lost, right? So depending on exactly what's going on.
Absolutely. And a good place to start to just learn about the process is the visa bulletin. So I've just put for everyone in the audience in the chat the link to the most recent bulletin. So take a look at that. Take a look at the laws and regulations that are actually on that webpage as well if you're curious about the process. Um, for someone on an E2 investor visa, what are the requirements for renewal? And do those requirements rise each time you renew? Um, Okay, so first of all, I'd say check out our E2 webinar. We've recorded many E2 investor specific webinars. Those are on our YouTube channel, and we talk a lot about the renewal process. Um, but the second part of the question, if you've renewed your E2, you're 65, you want to retire, can you stay in the US? Or do you need to move back to your home country? So maybe this is a good opportunity, Ian, to
Yeah,
just touch again on how you apply for a green card in the
yeah,
US based
yeah.
on family or employment.
Yeah, so I think I think that one of the things that you might want to consider if you want to kind of retire is maybe semi-retire, right? So with the E2, absent any other category that we just talked about, because unfortunately the only categories are the only categories other than the ones I didn't talk about, but the ones I talked about are the most common ones, right? So the only way to get a green card in the United States is through one of these mechanisms that I talked about. And I think even though we may not have covered the subsections of each category, this is it, right? Like employment based is EB1 through EB5, family based is what I talked about, and then the other ones are kind of, I'll call them almost fringe categories where they're not that common, right? Like they're not that common. They're not available. Like asylum is not available to the average person, right? So and these humanitarian categories are not that common, right? So, but what you could consider with E2 is semi-retire, right? Because E2 requires that you develop and direct the operation, but that can be like, part-time, right? Like there's nothing in E2 that says that the investor has to be full-time. So it could be that you renew your E2, because the renewal, like the government doesn't care. Like a renewal is not like, you could have I use this example all the time. We have E2s that are pool cleaning businesses where they have three equivalent of three full-time people that are making $10 an hour, and that's all they ever had for 20 years, right? And that's completely fine. There's no And E2 doesn't require that you expand your business and continue hiring people and things like that. It's just a set number and you can continue on. So it could be that maybe like in terms of semi-retirement, you hire another, you hire a manager so that you're still involved with the business, because you can't just like you can't just be like have a passive business on E2. But that might be an option, an option for you. Or if you have, depending if you have depending on if you have kids and things like that, and if those kids have, because that's another, under the family-based category, that is a very significant number of our clients end up getting green cards through their kids, right? So under the family base, so let's say the child, someone's here for a long time on an E2, the child turns 21, maybe finds another visa or something like that, and then they marry a U.S. citizen. So then all of a sudden, once the child becomes a citizen 3 years later, that child is able to sponsor their green card, their parents, under the immediate relative category. right? So that's definitely because children over 21, if they're U.S. citizens, they can sponsor their parents, and there's no backlogs in that category ever. That the immediate relative category does not get retrogressed. It's always available. So, and immediate relative is going to either be U.S. Citizen, marry their spouse, or a child over 21 that is a U.S. citizen sponsoring parents. So
Perfect. Thank you so much, Ian, and thank you all to our participants today. Great questions. So do keep an eye out for the email, which we'll send to you all soon. Please do visit our YouTube channel, and we hope to see you on future webinars. Ian, thank you so much
great.
for
Thank you very
your
much,
time.
Dustin. Okay, thank you. Bye bye.